Lennon, and this week I'm continuing on with our Family Law Alphabet series, talking about words starting with the letter H. I'm going to focus on two words in particular, which are hearings and hearsay. These are two words that you will commonly hear should you engage in family law proceedings, so particularly if you go to court, is what I mean by that. So let's start with hearings. So the word hearing suggests going to a final hearing and battling it out in court, which is typically what people think of when a lawyer will say to them, you might need to go to court. Court isn't always like that though. So I think the way I categorize my mind in terms of the way things work are there are three types of listings you can have. There's actually plenty more, but three main categories. One is what's called a directions hearing or listing. What these are administrative occasions when you go to court. No major decisions are generally made on these days that will impact your matter. So for example, no one's going to decide on that day unless something really urgent or risk associated is happening in your matter. No one's going to decide on that day the final outcome of your matter. They're not going to decide who your kid's with or like what percentage you're going to get. That doesn't happen. Basically, directions, if you think of it in the basic sense of the word, means how are we going to progress the matter? What directions can we make to make things move on? So in matters, you might have, for example, a direction that you have to go to a child dispute conference, or a direction that you might have to go to mediation, provide disclosure, that a children's lawyer be appointed. So lots of directions can be made on those days. And as I said, they're kind of admin days before the court, but often they're a really, really good opportunity for all the parties to actually get together and have settlement discussions. So really, really regularly, parties actually resolve their matters at these particular listings. The second type of hearing is called an interim hearing. These are quite common. If you go to court and have any urgent issues or issues that cannot await a final determination of the matter, which could be 2 to 3 years away, you'll have what's called an interim hearing. So an interim hearing is conducted on the papers, and what I mean by that is it's not the courtroom that you think of where someone's up in the witness box being cross-examined. It is literally the judge will read what you've both set out in your respective affidavits, applications, responses, any subpoena material or tendered documents, and make a decision based on that and the submissions of your counsel, barrister or solicitor. So that's an interim hearing. Quite common if you do go to court that you will have one of those. The third type of hearing is the classic one that everyone thinks that they're going to when they go to court. This is the one that you'll see on TV, the real Americanized version, although Australian courts aren't conducted like that. It is the final hearing, also known as a trial. So this is where someone is actually sitting up in the witness box being cross-examined about the evidence that they've given. It normally takes weeks, if not months, to prepare for these particular kinds of listings. You will have a barrister, if not two sometimes, on each side. They're very expensive and they take anywhere from 1 day to multiple weeks. The massive matters can actually take months to sit and be conducted in that way. So that is the classic trial or hearing that you would hear of. However, if you engage in proceedings, there is a really high unlikelihood that you will be going to a final hearing. We like to say, and I think that this is statistically about right, only 1% of matters or less actually go to a final hearing. So statistically, if you're going to court, because of all those directions listings and the interim listings that I spoke about earlier, there's a very, very good chance that, fortunately, you don't have to go to that final hearing. So it's much better to resolve beforehand as well. Okay, second word is hearsay. So hearsay is kind of a technical term, and you won't hear it unless you do go to court. So hearsay comes under the Evidence Act. And basically what that means is that you cannot adduce hearsay evidence. And hearsay evidence is any written or spoken statement or conduct that is made outside of the trial itself. So for example, someone says something out on the street that is being used to provide the truth of a statement or conduct of a fact in issue in the matter. That all sounds very complex. Basically it means, and look, there's plenty of examples you can give here, that you can't say, well, I heard Bill say to Jess that she went to the shops. You can't say that because that person should be able to give that evidence, and you should call upon that person to give that evidence directly themselves, and then they're saying it themselves. It's not repeating kind of what you've seen or what someone else has said, basically. That's a bit complex and you probably don't have to worry about it yourself. It's more something that your lawyer will worry about for you. Any such statement, hearsay statement, has multiple exceptions to that rule. So for example, in family law proceedings, basically when you have an interim hearing or an interlocutory matter that is being determined and they are considered on the papers, those kind of statements are actually allowed. It's an exception to the rule. There's a whole range of other ones, but I won't bore you. But if you go to a final hearing, that really rare type that I spoke about before, those kind of statements would be struck out. So it's really important that your affidavit is well drafted to ensure that none of those statements are included, because you might erode a lot of your really good evidence that's there otherwise. Okay, next time we will be talking about words starting with the letter I. I might touch upon in a little bit more detail the interim hearings that we spoke about this week. Thanks, tune in.